This is a very rich panel with many important papers on it, and the difficulty is that it addresses a topic, the Jewish impact on law and legal theory, and all the papers have a different notion, for example, of what Jewish means in this. You know, for some, for example, in Nomi's paper, it refers to Orthodox groups. For Morty's paper, it refers to a set of people who are just out of the ghetto and being emancipated and having the shock of emancipation. For Dahlia, it refers to the next generation, Felix, as opposed to Morris. For Mark, it refers to Jewish groups, organized Judaism. For Suzanne, it refers to a notion of Jewish law, or those who assert a Jewish identity. And for Sandy, it refers to on the other hand, if you take the other half of this equation, if you say, you know, law and legal theory, what is law and legal theory? I mean, again, we have a totally different set of understandings of what these things are. For Morty and Dahlia, it's something in the neighborhood of political theory and social theory, and how whatever Jews are connect to that. For Mark, it refers to constitutional outcomes. What is the actual separation of law and state? I take it it's the same thing for Nat's contribution. For Suzanne, it refers to what's in the case law by way of references and what's in the scholarship. For Nomi, it was a little hard to get from the verbal portion of it, but from the notes that I got from Nomi, it would refer to the borderline between the setting of the religious and secular law and how these things interrelated through the use of private law. And for Sandy, it refers to. All of these things have a different, all of the papers also have a different notion of what actually the causation is on this. In some of the papers, we're talking about historical analysis of the causation for Morty, and some, the lens is biographical for Dahlia, for example, and for Sandy. For some, there's a social structural kind of explanation, that's Suzanne. For some, there's a story of changing interests, and that's for Mark. As the interests of the Jewish community change, so is the connection between Judaism and legal theory. And so we're dealing with different mechanisms of explanation, different forms of explanation, different things that are being explained, hard to pull together. If I had to think myself, what is, if I had to just free associate, lie down on the podium as if it were a couch and free associate, what is the connection between Jews and legal theory? I would say, I think of like where I'm teaching. I teach at the Yale Law School. And I'm going to use as a metonym for legal theory, constitutional law, which comes as close as most areas of legal study do to legal theory. So who do we have at the Yale Law School? We have Akhil Amar, who's Hindi. And then who do we have? We have Bruce Ackerman, Owen Fiss, Jed Rubenfield, Paul Kahn, Reva Siegel, Robert Burke, Jack Balkin, and me. I'm now teaching at the Harvard Law School. So we have Richard Fallon. What is Richard? Baptist? Episcopalian?
He's one of them.
He's one of them. He's one of them.
He's the token.
He's the token. And then we have Martha Minow, Larry Tribe, Frank Michelman, Mark Tushnet, Frederick Schauer, Darrell Levinson, and we have Charles Freed, born a Jew, now an Episcopalian, right? So, but he's born, so he counts. So, I mean, this is pretty stunning. This is a stunning example of an influence of Jews in the academy who are studying and doing legal theory. So this leads me to two questions. First of all, what accounts for this stunning overrepresentation of Jews in the production of legal theory? And second question is, what difference does it make that there are Jews who are doing this? So none of, I'd say, the explanations we see, particularly on this panel, are going to help us here. None of these academics face the shock of emancipation in the way that Morty is describing it. And although some are maybe second generation, like Felix, the way Dahlia, I would say most are only vaguely pluralist in the sense in which you're describing pluralism. I would say that there is a movement in Judaism that I've witnessed in my lifetime from a religion to a multicultural identity. I used to be on the board many years at the Berkeley Hillel, and when I started, Hillel was there to provide services for the religiously observant. By the time I ended at Hillel, Hillel was there to provide a resource so Jews could enter Berkeley with the equipment of a cultural identity that would allow them to stand on equal footing with African Americans and Hispanics and so on. But none of these people, I would say, are multicultural Jews in that sense. None are Orthodox in the sense of the Satmars discussed by Nomi. None represent organized Jewish groups in the sense that Mark talks about. And none, with the possible exception here, Martha Minow or Robert Burt, speak about, use Jewish sources in the way that Suzanne is talking about, and most of them are like Standing. And so how do we explain? How do we explain this overrepresentation? And here I call to mind, I heard Moshe Habital in a conference at which Suzanne was, and he was describing a trip he took on an airplane. You know, this is the Jewish legal philosopher. He says he's on a plane, and he's sitting in the plane, and to the left of him is someone who's not Jewish, and they're having a great time. They're reading a novel, they're laughing, they're enjoying it, they're engrossed in their reading, and then they put it down, they read a magazine. And to the right of him is a black hat, you know, a Hasidic Jew, and he's having a great time reading the book, enjoying it, and he's reading what? He's reading a book of law. And Moshe Habital says, how many other people read law the way you and I read John Grisham? I mean, that's a very unusual cultural fact. And it may be that this is the thing that Asaf and Ruth were asking us to consider, this strange, ephemeral gap between Judaism as a religion, Judaism as a culture. But the problem I put to you is that none of these scholars that I've just put on the table read law for pleasure. You just don't see Larry Tribe and Bruce Ackerman curling up on the couch with United States Code annotated. You just don't see that. And I myself, for example, I'm going to be autobiographical. I read fiction for pleasure. I read nonfiction. Sometimes I read scholarship, but I wouldn't be caught dead reading a treatise, and I wouldn't be caught dead reading law for pleasure. So that's certainly not accounting for anything. Now, I think a little bit I'm going to generalize from my own case. I don't know my Harvard colleagues well enough to generalize for them, but I do know my Yale colleagues enough to know that I'm roughly speaking in the same ballpark, give or take, ceteris paribus, a number of things. So I grew up Jewish identified. You know, I went to Hebrew school. I studied, I went to Hebrew school, but I never studied halakhic law. I couldn't translate a page of Talmud if my life depended on it. I never engaged in the debate of sacred texts. I went to shul, but I heard them read the Torah, and to me it was gibberish. I didn't know what they were reading. They were chanting. And I engaged in lots of rituals at home. And I assume most of the people I'm talking about, the legal scholars who are contributing to legal theory who are Jewish, have something like that background. Some more or less, but mostly in that neighborhood. I would say all of us remember sacraments of memory, most especially associated with the Seder, where you recreate a community through a ritual that has connection narrative to a past. And I also remember a strong moral gyroscope. That is to say, it could be the vestigial remainder of the moralism that Morty was talking about. In my family, at least, and I think in most Jewish families, you get this tikkun olam. You get, you have to do justice. You have to stand up. But I think in this regard, Morty's paper makes a very pertinent point, which is that the historical moralism of American law, I think, should be understood less as a contrast between Jews and the Goyim than as a contrast between America and Europe. And you can see that if you compare two preeminent Jewish theorists, the preeminent Jewish theorist that Suzanne is talking about, Ronnie Dworkin, who's got a very strong moralist and historical streak, the Chain novel, who is Jewish, and you compare him to the quintessential English jurisprudent who's Jewish, H.L.A. Hart, who's totally positivist. And the distinction there has a lot to do with the fact that in England, law focuses on positive. Law is understood to be positivist, to be legislative focused, and in America it's understood to come out of the common law, judge-centered, and that's a very strong outlet for moralism and for narrativity. And it could be, of course, that this is attractive to Jews, and I don't want to rule that out, but I don't see why it wouldn't be any more attractive to any other American brought up in the common law tradition than it is to Jews. So it is attractive, no doubt about it, but that much more attractive, I don't know. So when I think of myself, I'd say I put the stress in a slightly different place. And I think Mark Stern's paper helps me understand why. Because Mark describes a very interesting development in the history of the litigation of organized Jewish community. After World War II, Jewish communities became confident enough to litigate, to bring suit, but they were ill enough at ease, and they were insecure enough to have to bring suit. So Mark is describing a very delicate balance between a community that can assert itself and use the law and thinks of the law as an avenue in which it can assert itself, and yet is insecure enough to need to use the law to protect itself. That's a very delicate balance, and I say I would recognize that balance in myself.